Ms. Schobel, we'll be happy to hear from you.
Thank you, Your Honors. May it please the Court, Diana Schobel on behalf of Mary Johnson and Ford T. Johnson. This case involves the propriety of holding two corporate officers, Mr. and Mrs. Johnson, personally liable for employee payroll taxes owed to the United States by COBA Institute, Inc., the corporate employer for quarterly tax payments ranging from 2001 through 2004 under Section 6672A of the Tax Code.
Are you going to address Mrs. Johnson or Mr. Johnson?
Primarily Mrs. Johnson.
Mrs. Johnson.
Mrs. Johnson, Mary Johnson, correct. Now, the District Court for the District of Maryland believed that it was proper when it granted the United States motion for summary judgment and entered judgment against the Johnsons for hundreds of thousands of dollars in back taxes. We contend that that decision was incorrect and are asking the Court to reverse. Now, again, our primary argument is with respect to Mrs. Johnson. And in imposing personal liability on Mrs. Johnson, the Court necessarily needed to find that Mrs. Johnson was responsible for COBA's decisions regarding withholding and payment of taxes. And she would be liable if and only if it was shown that she was, one, responsible for the collection and payment of the taxes, and two, willfully failed to see to it that those taxes were paid. And of course, since this was...
When you use that first prong in your example, responsible for, isn't the test fairly universally, if not completely, applicable in all of the circuits to address liability under this statute? It's whether you have the power and the authority to take care of the taxes, not whether it's your particular responsibility, because nearly every corporation or business entity has a financial person whose responsibility it is to pay the taxes. But they're not a shareholder, they're not an officer.
Well, that's correct, Your Honor. However, in determining if somebody is a responsible party, there's a number of factors that goes into determining whether there is that requisite authority. And simply being a title holder with a corporate officer position isn't necessarily going to make someone a responsible party. Having check signing authority is not necessarily going to have is not necessarily going to be dispositive.
But in terms of what is, it's not disputed here, is it, that Mary Johnson had the authority to pay the taxes and ultimately did?
That she ultimately did pay the taxes?
I believe when she learned that, after learning of the deficiencies, she said, see to it.
She engaged Mr. Johnson, who was actually the one running the company at the time. Mrs. Johnson, she was a shareholder of the company. She was one of three members of the board of directors, and she was vice president. But in terms of the practical day-to-day role...
The record indicated she was the sole shareholder.
That is correct, yes. But...
She found out the taxes that are at issue here were not paid. She fired the finance director.
And directed that they be paid, did she not?
Going forward.
Well, I believe that she directed Mr. Johnson to... Mr. Johnson did all the hiring and firing, so I believe...
He directed that they be paid by someone.
That is correct, yes. But during the period at issue between 2001 and 2004, she had no knowledge that they weren't being paid.
Does it matter?
I think it matters because I think the courts look at this on a case-by-case basis, and I think that this is more akin to the situation in the court's decision in O'Connor, where you did have somebody who was a shareholder, who was a corporate officer, and who did have check-signing authority, but the court did not find in that instance that he was responsible.
Wouldn't it look a little odd if we hold that somebody who's the owner and sole shareholder of the company,
Chairman of the board.
chairman of the board, signing leases, signing loan guarantees, taking out loans for the corporation, making major personnel moves like firing the finance director. I mean, if we say she's not a responsible person, wouldn't we look ludicrous?
Well, I think, Your Honor, the court would be looking at this situation on a case-by-case basis, because these are very fact-specific kinds of cases. And while she may have signed certain things, again, she was not involved in the decision-making process. She was not involved in the payroll. She was not involved in the hiring and firing.
But unlike the O'Connor case, here, once the deficit in taxes came to her attention, in the succeeding years, she drew well over $500,000 in compensation and paid any number of other creditors of the business. And that sort of bleeds responsibility and willfulness together. But that's not a factor that a court can ignore, and it certainly distinguishes the case that you cited, where the person who was sought to be held responsible as a responsible person didn't get anything.
Mm-hmm. Well, I think one of the...
How do you get around that?
Well, in terms of, if we're getting into the willfulness, in terms of paying other creditors, as a practical matter, the only way you really can continue to exist as a viable business is to continue to pay your other creditors. That's just the reality of it.
The question, it wasn't just that she paid other creditors, she paid herself significantly after she learned of the deficiencies. Doesn't that establish, under our precedent, willfulness as a matter of law?
Well, the case law does indicate that can establish willfulness as a matter of law. What we're asking is that the court maybe rethink that in terms of the fact that not so much the payments to her, but the payments to the other creditors, again, were necessary to keep the business up and running so that the business could continue to make the payroll taxes.
Really, I mean, the law requires the IRS have a position of preference, and the reason is that, I mean, nobody's a great fan of taxes, but the withholding taxes for FICA and employee income are absolutely the cornerstone of our whole tax system. That's how the government gets a massive part of its revenue. And, you know, a lawsuit like this just seeks to chip away at the foundations. And somebody with all of this authority, making personnel moves, signing critical documents, chairman of the board, sole shareholders, all these different things. We're not going to, if we were to say that they weren't a responsible person, that would be alarming. I mean, probably cause for summary reversal. And to say that there's no willfulness here and reverse Judge Chasnow on these points, when she knows she's got to pay her liability under these trust funds to the government first, and she can't just go at her desire. The law doesn't allow her the latitude to sort of pick and choose among creditors, and it certainly doesn't allow her to put herself at the head of the line. As Judge Duncan points out, there were very significant payments made to her that should have been made to the Internal Revenue Service.
Well, respectfully, Your Honor, I would also point out that from that point forward, the payroll taxes were getting paid, and were getting paid in a timely manner. And there were also payments made under an offer and compromise made with the government on a regular basis. So the payments were going to the government at that time. Did every resource of the company go towards those taxes? No, they did not. And that...
But doesn't it also, I mean, it proves at the same time, and if you're aware of some evidentiary rule that the same evidence can't prove responsible person and willfulness, you should tell us about it. But nothing happened with Mrs. Johnson's authority between the period where the taxes that are now at issue were unpaid and the taxes that were paid thereafter were paid by her direction. She had the same authority during all those periods. She just decided she better exercise it once she found out that the taxes at issue here were unpaid. Doesn't that prove that she's a responsible person because she exercised the authority fully at that point? Authority she'd always had?
Well, that could be a consideration, but again, as a practical matter, having not been involved in the operations of the company up to that point, I mean, she didn't even know which creditors to pay or who to pay. That all came at the direction of Mr. Johnson. And maybe after discussing this with Mr. Johnson, she had an idea of what to do about this, possibly. I'm not sure. I'm not sure if that answered your question, Your Honor.
Well, you did what you could.
Okay.
I don't want to take you off. You can argue whatever you wish to, further about Mrs. Johnson, but before you go, I want to ask you about Mr. Johnson's statute of limitations argument. I'm not quite sure what it is. You've raised the issue, your last assignment of error number 5 says that there was an error in determining that the assessment was made within the 3-year limitations period. When we look at the brief on page 30, we basically got one paragraph that says this was assessed after the expiration of the limitation period, but I'm not quite sure exactly what you're trying to say there. So articulate for us, if you would, what the statute of limitations argument is.
Well, Your Honor, that goes into the timing of an assessment notice that Mr. Johnson never received, and that was not found as part of the Internal Revenue Service file.
Is that the Form 1153?
Yes.
I thought that he conceded that that was, that the issuance of that was valid. I didn't recall that he raised that issue as a statute of limitations argument in the district court. I thought his argument was that and I'm not trying to tell you what your argument is, but this is what I understood it to be, based on reading Judge Chasnell's opinion and this paragraph in your brief. I thought your argument on the statute of limitations was that the Form 4430 was issued after the statute of limitations expired, even though the assessment that's reflected on it was made within the statute. I thought your argument was that since the actual form was completed later, that was the statute of limitations period. You tell me if I'm right or wrong.
No, I think they're both components of that. I think those were both included in that argument.
Well, did you make the argument in the district court that the Form 1153 that he acknowledges was sent, that is part of your statute of limitations argument? Did you argue that to the district court?
Well, I did not, because I was not counsel in that case
Well, based on your
below.
understanding of the record, was that argued?
I'm sorry, I'm just not sure right now.
Okay.
Why would, I had a problem similar to Judge Agee's, which actually led me to the suspicion that the statute of limitations argument may just have been abandoned because it was impossible for me to understand what it was. And there is an obligation on the part of the parties to make an argument in a form that is sufficiently comprehensible to enable review.
Thank you, Your Honor.
You don't wish to respond? It's a bit unclear, it's a bit murky to me as well what the statute of limitations argument is, and does that not at least militate in favor of our not considering it because we are unclear, or is it just that we are missing something?
I think that the argument had to do with, the argument was that the assessment notice was sent after the limitations period to Mr. Johnson, and he never received that. And then secondly, that the record of the assessment itself was created outside of the limitations period
But the
of those
point
two
is,
components.
I mean, the district judge listened to these arguments and rejected them. And you don't give us any reasons as to why we should reject the reasoning of the district judge. I mean, you just restate it, but there are no reasons supplied as to why the district, you don't take on the district judge's reasoning at all. And, you know, I think Judge Agee's right. There are all these different forms that are floating in and out, and when they were sent, and this and that, and it's just, there really isn't any coherence to it. And I'm not blaming you for it, because I think there's probably not much to it, but I think you probably put your strongest foot forward and place the emphasis where it should have been placed. But, you know, the party seeking a reversal has some obligation to show the court why that should be done.
I understand, Your Honor. In the remaining time,
In fairness to you, I think the Form 4340 argument was made in the district court, and the district court judge did address that at some length. It's just, as Judge Duncan points out, it's hard to tell in one sentence in the brief how you've brought that forward to us, but we've probably spent enough time on that.
thank you, Your Honor. In the few minutes I have, I did want to address the fact that there was also a material issue, a disputed fact with the amount of the assessment that the court ultimately reduced to judgment against both Mr. and Mrs. Johnson. At the time of, the Johnsons had submitted expert reports based from.
Can I ask what the standard of review under 6672 is? Is it when you say that the district court erred in determining the amount of liability, or reviewing that under clear error standard? It's a clearly erroneous standard, isn't it? Finding of fact.
Well, the court entered summary judgment when there was a dispute of material fact as to the amount of the judgment. So I think Your Honor would be reviewing that de novo.
But in terms of what, it's your job to press the genuineness of a dispute and the materiality of a dispute. And I don't see how you can do that with respect to this Mr. Brewett's testimony, because when the government filed its motion for summary judgment in front of the district court, the taxpayer never relied upon the Brewitt testimony in opposing summary judgment. Mr. Brewitt's testimony just didn't make an appearance in the relevant documents. Now all of a sudden, they're saying, well, we ought to be reversing on the basis of Brewitt's testimony. But if it's reversible error and whatever, why wasn't it included in the opposition to the government's motion for summary judgment?
Again, since I wasn't counsel below, I'm not sure specifically what the thought process it was in that. However, there was a pending motion to strike the expert report. Again, they had been submitted to the court, and they were part of the record. So I believe that.
Did Brewitt's report even appear in your own? You filed there were cross motions for summary judgment, weren't there?
Correct.
Well, did Mr. Brewitt's reports appear in your own summary judgment motion?
I don't believe they were cited there either. They were part of again, they had been submitted to the court. There was a motion pending.
Well, if neither Mr. Johnson or Mrs. Johnson didn't discuss or cite Mr. Brewitt's report in their opposition to summary judgment, in their own motion to summary judgment, his reports were never submitted as any kind of exhibit attached to the opposition to the government's motion for summary judgment, and there's no use made of them, and then you're up here on appeal saying there's a genuine issue of material fact when there's no mention of them. They're not submitted as exhibits to the trial judge in connection with the summary judgment motion. There's no mention of them in the summary judgment motions.
It appears
So how did that become a basis for reversible error?
Well, Your Honor, the court, there was a motion for reconsideration subsequently filed, and the court did have the discretion to go and take a look at those at that point to the extent the judge was not aware of it. So we're saying that the court should have exercised her discretion and then gone and considered it at that point in time.
Thank you.
Thank you, Your Honors.
Ms. Wolfinger, we'd be pleased to hear from you.
Good morning, Your Honors. Gretchen Wolfinger for the United States. I will begin by briefly addressing the responsible person status of Mary Johnson. It appears from comments and questions from the bench that the court has a good grasp of the facts and the implication of those facts in this case. She was the sole shareholder. She was the sole financer of the company. She was the chairman of the board, and she used that authority to appoint her husband president and herself vice president.
Didn't we cover all that in our questions?
Yes, and I will certainly move on then. Thank you, Your Honor.
Practical implications of this are that someone could endow an individual with all kinds of titular authority and park the assets of the corporation and dividend payments and a closely held corporation and salary and all kinds of other assets, and then say later that this authority was purely nominal and that the individual is not a responsible person because it was nominal authority, and then all kinds of corporate assets are parked in the name of the nominal party. I mean, we'd be creating a giant loophole. Here's how you get out of paying your trust fund taxes.
That's exactly right, Your Honor, and this circuit's case law speaks to that.
And I'm sorry, I would like to rephrase my question and say, is there anything we didn't cover in our question?
Thank you, Your Honor. I believe the only thing that hasn't come up factually in regard to Mrs. Johnson was that she was not only exercising titular authority. She did show up at the corporation, and in fact, she appointed herself or called herself Director of Human Resources or Relations. So she not only had the authority on paper, she was actually showing up at the corporation, and I believe it was her husband.
Signing some pretty important legal documents, and they were binding. You know, she was taking out loans.
Yes, guaranteeing things, leases, and also, in the words of her husband, she wanted to be Human Relations Director because she wanted to keep her hand in the pie, which certainly rebuts any argument that she was solely a passive investor.
Now, we do have your brief and everything, and perhaps a short answer to Judge Duncan's question would be advisable.
That was my answer, and I was prepared to move on if the court would like to discuss the statute of.
Maybe, I don't want to speak for my colleague here, but it may be that the question covered the case as a whole.
I am certainly prepared to sit down if that's the court's desire.
Your brief on the statute of limitations contends that there's a waiver of the entire issue or just component parts?
No, I believe the entire issue is waived for two reasons, or it may be the same reason, different sides of the same coin. The fact that the basis for the district court's decision and the reasoning of the district court was not rebutted or challenged in any way by appellant, and the fact that any argument that was made was, I believe, in the words of the panel, difficult to understand.
Okay, thank you.
Is there anything? Thank you, Your Honors.
Thank you, and, oh, don't worry. I'll give it- Michelle, who do you want? Do you have anything you wish to say? Okay. Oh, all right. Well, we'll come down and greet council and take a brief recess.